We're just waiting a few more minutes to have the slide deck up and we can kick off. Dana, could you go back one slide, please? I believe we're good to go. Thank you, everyone, and welcome to everyone joining us today on this webinar hosted by the International Ethics Standards Board for Accountants, which is the IESBA. Today, we'll be discussing the proposals in the Tax Planning and Related Services Exposure Draft, which was issued on February 17 with a closing date for submission of May 18. Next slide, please. My name is Kala Vijin. I'm a principal with IESBA and staff lead on this project, supporting the Tax Planning Task Force. We're very fortunate to have with us today Professor Jans Pohl, who will be taking us through the key proposals in the exposure draft. Professor Pohl became a member of the IESBA in January 2018. He serves as a non-executive director and audit committee chair in several medium-sized companies with global activities. He presently serves as an independent chair of the European Group of International Accounting Networks and Association, and is a vice chair of Accountancy Europe. Professor Pohl holds professional degrees as public accountant, lawyer, and tax advisor in Germany. I would like to brief participants of a few house rules before we start. You're welcome to pose your questions on the chat function anytime during the session, and we'll endeavor to answer all of your questions during the Q&A session. During this session, you may raise your hands function to pose your question. If we do run out of time and we do not get to your questions, we will be posting those questions on our website following the conclusion of 3 webinars, along with answers to questions that you pose. The presentation slide deck will be made available to you after the session today via the email you registered. And the video of this webinar will be posted on our website in due course, so you can access it anytime at your convenience. Next slide, please. Some of you will be familiar with some of the news headlines in relation to organizations or individuals who have been criticized or found to have breached the code of ethics or conduct in carrying out tax planning services. Starbucks, for example, and as a few other famous household names, have been found to not meeting the corporate tax obligation in jurisdiction that they operate in. Separately, a tax practitioner was found to have breached the fundamental principles of conflict of interest for sharing confidential information about government plans to target multinational tax avoidance with the firm's clients. These are some of the examples of the cases that's prevalent in the market these days. We wouldn't be going into detail of some of these cases, but these are just some of the scenarios we view where the Code of Ethics can provide some form of guidance to professional accountants should they encounter an ethical dilemma in these circumstances. Next slide, please. So a brief background before we come to the proposal. In early March 2022, the IESBA announced that we will host a global series of virtual roundtables on the tax planning project. The roundtables will aim to bring together a broad range of stakeholders to discuss state of play on the topic of tax planning and explore how the board could formulate a proposed ethical framework to guide professional accountants in business and in public practice when providing tax planning services. Next slide, please. The 3 global world virtual roundtables were organized to cover specific regions, as you see in the slide in front of you: the Americas, Europe, the Middle East, Africa, and Asia Pacific. There were close to 100 delegates that participate in these events. Various stakeholder groups, including regulators, public authorities, representatives of the legal profession, national standard setters, professional accounting organization firms attended these roundtables, and this slide provides an overview across the different jurisdictions presented. Now, going into the ethical framework, next slide, please. What you see in here is the proposed ethical framework that will cover through the proposed new sections 280 and 380. This framework was formed out of the input that we received at the roundtables. The discussion we had at the roundtables highlighted how intertwined, complex, and multidimensional the ethical consideration can be in addressing tax planning services. So the IESBA is of the view that focusing on developing principle-based framework is the appropriate way forward because of the wide variety of tax laws, regulations, and practices around the world. So global applicability is an important consideration. Equally, it will be important not to avoid being drawn into analyzing the merits of particular tax strategy plan or adopted by employing organizations and clients, or debating about the tax policy. Next slide, please. As we work through the remainder of the presentation, the next slide, please. We're proposing two new sections, 280 for PAIB and 380 for PAPP. Both sections will apply to all entities, whether it's a public interest entity or not. And section 380 will apply to all types of clients. In this slide deck, we have also included the link to the expiring memorandum, where we have provided more explanation on the various proposals. Without further ado, I pass the floor to Jans, who will take you through the key proposals in the exposure draft. Thank you, Jans.
Thank you, Carla. Thank you for this introduction. And first of all, a very good afternoon, good morning, good evening. And I hope you will have an interesting journey with us through our exposure draft, which is now for comment. First, I would like to say, and Carla mentioned it, we have two sections, 280 and 380. But I would like to highlight that this exposure draft is for the accountant doing purely tax services. So it has no connectivity with any other related services, for example, audit. So it is not the hot topic which tax services are permitted as an auditor. No, it's about the accountancy profession doing tax advice. I'm highlighting this because we have just in the last year the new provisions of section 600, where all the issues of aligning and prohibiting and allowing certain services along an audit engagement. So that is not the scope we are looking here. So next slide, please. The key proposals I would like to highlight in this the next 30 minutes or so are the following. So it is about the role of the PA in acting in the public interest. It's about a new term we decided to use. It's seeking a credible basis for a certain tax advice. Then I would like to look at the consideration of the overall tax planning advice or recommendation, to look to the multi-jurisdictional tax benefit, and I want to demonstrate how we try to make further guidance to the application of the conceptual framework in the connectivity of tax planning services. A specific part is on disagreements between client or employing organizations and PA. And last but not least, some considerations about documentation. So the next slide. Acting in the public interest is a notion we have in the code. So it is a long tradition, and it's a long established principle that a professional accountant in business and in public practice is acting in the public interest. But what does it mean in the context of tax planning services? So it's quite easy, next slide please, to demonstrate the public interest when you are acting as an auditor. But here, as I mentioned earlier, we are looking at the role of a professional accountant, not doing anything else than tax advice. So first of all, professional accountants are expected to exercise their professional judgment, full stop. We discussed lengthily about a definition of public interest, but we saw, especially in the context of tax planning and tax services in general, that there are probably more than one public interest. There are more public interests, plural, because in certain jurisdictions there are different definitions, different cultural environments, etc. So we decided as IESBA not to try to define or describe the public interest in abstract in the context of tax planning services. But we acknowledged that a large part of acting in the public interest is to assist clients or employing organizations to comply with tax laws and regulations. So the PA role is to navigate the client in a quite complex or sometimes complicated environment. And it's clear that the role of the professional accountant is here a very specific one. And I would like to describe it like this, that a professional accountant on the one side has to inform the client, make the client capable to understand the laws and regulation. That's one issue. But on the other side, they have the broader public interest, but we are recognizing that the professional accountant has to make clear that it's the client's or employing organization responsibility to pay their legally assessed tax duties. But there's something else. There's a reputational risk to clients and employing organizations and to the profession. And these are important considerations too. Next slide, please. So here you see some application material on professional accountants' public interest role. It's 384A2. I don't want to read the whole text, but clients are entitled to organize their affairs for tax planning purposes. So we are acknowledging this is a good reason to do so. But there are many ways to achieve such purposes. And we are describing the different roles of the advisor, of the client, and the employing organization. So it is important that professional accountants' role is to advise their clients on how best to meet their tax planning goals. But there is something else that when accountants provide such assistance in understanding tax laws and regulations, there are also possibilities of minimization of taxes. And there the possibility is that there are structures which are not prohibited by tax laws and regulations, but we are addressing here the point, even there might be the possibility of threats to compliance with the fundamental principles. On the next slide, we are trying to define the credible basis. The credible basis is a term we developed after lengthy consultation with stakeholders during roundtables and during outreach activities, where we want to find the basis on which a professional accountant may do his or her tax advice. Next slide. We want to clarify that a PA can only provide or recommend or advise on a tax planning arrangement if the PA has concluded that there is a credible basis. So it is not our aim to prohibit any consultation or communication or discussion with a client in the process of determining what are the objectives of a certain structure, of a certain tax advice, and how to reach or to get a credible basis for a tax planning arrangement. We have a lot of application material added in paragraph 380.11a1. And we are also clarifying that determining whether there is a credible basis will require the PA to exercise professional judgment. And this is based on the tax laws and regulations at a certain time and moment in time. We are thinking at IESBA that a credible basis must ultimately be anchored to the relevant tax laws and regulations. So this is a credible basis in law and regulation. This might be specifically challenging in a cross-border situation, but I'm coming to this specific situation later. Next slide, please. So we have established or are proposing a requirement that a professional accountant shall recommend or otherwise advise on a tax planning arrangement to a client only if the accountant has determined that there is a credible basis in laws and regulations for the arrangement. And in the application material, we are clarifying that this requirement is not precluding the accountant from explaining or advising the client the rationale for the determination. And we are highlighting that this is an exercise where there is a need for professional judgment by the professional accountant, and that this credible basis will vary from jurisdiction to jurisdictions and based on the relevant tax laws and regulation at the time. I'm switching now over on the next slide to consideration of the overall tax planning advice or recommendation. Next slide, please. We are proposing in R380.12 a so-called Standback provision, which is a consideration by the PA of a wider perspective. It's the reputational, commercial, and wider economic consequence test, you can call it. And the professional accountant should look not only at the credible basis, but see which wider implication there might be. And this is a good faith consideration based on PA's knowledge of the context and circumstances. And we are highlighting again at the time where we are giving a certain advice. So there is no expectation that the PA will be subject to hindsight judgment, and it's the PA's and not someone else's judgment, and it's not about tax morality or social justice. And you can take here the Standback case, which Carla mentioned in the introduction. The Standback case, as far as we are knowing the facts, is a case where there is a credible basis in laws and regulation. So the advice which was given is fully aligned with all jurisdictions involved. But nevertheless, we all know the story. In the end, there was a huge outcry by the public, and there were protests, and consumers boycotted the corporation here. So there were wider implications, because in the end there was how to say, there were some concerns raised by consumers that the actual tax rate paid in UK in that case was not appropriate. So having a very low tax rate, even though it's fully legal, it's fully aligned with laws and regulation, may have some impact, where we think that the client should be aware of this consequence. So we are enlarging the scope of the advice of the professional accountant doing tax advice, that he or she should look at the reputational, commercial, and wider economic consequences, and talk about and discuss this with the client. Next slide, please. Here we see the requirement in 380.12, which we are proposing, that in addition to determining that there is a credible basis for the tax planning arrangement, the PA shall exercise professional judgment and shall exercise in considering the reputational, commercial, and wider economic consequences that could arise from the way stakeholders might view the arrangement. In the two following application paragraphs, we are trying to describe the reasoning why we are setting up this requirement. And we have a requirement in 380, another requirement 380.13, which is about the possibility or the necessity that if a professional accountant decides not to recommend or advise on a tax planning arrangement that the client would like to pursue, the accountant shall inform the client of this and explain the basis for the accountant's conclusion. So we are highlighting the communication between the client, the employing organization, and the PA, and we want to make clear that the professional accountant in this specific area of tax planning and related services has a wider role to play in giving only a legal advice, but also have a wider scope of looking at the consequences, because a professional accountant is expected to act in the public interest. Next slide, please. We are looking in our exposure draft also to multi-jurisdictional situations, and specifically to those situations where some specific benefits are occurring. We know tax advice is a complex area, doing tax advice in a cross-border situation even more. We, on the one side, want to make aware the professional accountant that what is acceptable, what has a credible basis in the own jurisdictions, in the national jurisdiction, might be seen totally different in another jurisdiction. And on the next slide, we want to clarify what ethical issues might arise from a cross-border tax planning arrangement, and versus when there are tax benefits to the client or employing organizations. We are proposing guidance in this context, and it's guidance about the relevant factors a PA might consider in determining whether to make some disclosure. And we are giving also examples of factors provided, but these are only examples, and it's not an exhaustive list. During our outreach activities and roundtables, questions were raised about the involvement of external experts. We want to make clear here that there's a separate work stream, a separate project now ongoing on external experts, so it's not a scope of this project. Next slide, please. On the next slide, we want to bring the connectivity between doing tax planning services on the one side and to the application of a conceptual framework. On the next slide, you will see a picture you all will have seen during our roundtables, and I think it gives me the opportunity to clarify. If we are on the red zone, That's not the scope of the project here because it's non-compliant with laws and regulation. It's crystal clear that PA is prohibited to act in the context of the clearly illegal tax planning structure. He's not allowed to promote, he's not allowed to implement, etc. On the other side, there's a purely green area, which is clearly legal, where there is a credible basis and there are no wider implications to be considered. To all these situations, the conceptual framework applies, but especially we are looking at the gray zone where it's not so easy to develop whether there is a credible basis, where we are in the gray zone, and we are coming step by step closer to the green zone or closer to the red zone. So the conceptual framework applies here. So for the gray zone, we are proposing on the next slide in 380.15a2 a description of circumstances that might give rise to uncertainty. So it's the difficulty in establishing an adequate factual basis. So we are highlighting that it's the client's obligation to give all the factual information. Then there might be difficulties in establishing an adequate basis of assumptions. And then there is a lack of clarity in the tax laws and regulations, in the interpretation. There are gaps in the tax laws and regulation, challenges to previous court rulings. We have conflicting tax laws. It's not everything in line. And there might be different jurisdictions involved in cross-border transactions, even more complex. There might be new business models, innovative business models, which are not directly or indirectly addressed by the current laws and regulations. And there might be court cases, recent court cases and rulings or positions which cast doubt on similar tax planning arrangements. And there might be complexities in interpretations or lack of legal precedents, rulings or positions, everything is dependent on the jurisdictions and the judicial system in which you are operating. And there might be also a lack of clarity of the economic purpose or the substance of a certain tax planning arrangement. And that is a connectivity to the AML laws, which are also diverse in certain jurisdictions, and lack of clarity about the ultimate beneficiaries of a tax planning arrangement. So on the next slide, you will see our 380.16, where we are establishing a requirement, where there is an uncertainty as to whether a proposed tax planning arrangement will be in compliance with the relevant tax laws and regulations. A professional accountant shall discuss the nature of the uncertainty with the client. Again, we want a clear communication between the tax service provider, the accountant, the tax advisor, the tax lawyer, or who else is doing the service. And the discussion should serve a number of purposes. So it's about the explanation of the assessments and the interpretation which are possible, the assumption that might need to be made or changed, perhaps how to achieve additional information, and by that reducing the uncertainty, discussing also the reputational, commercial, or wider economic consequences, and also discussing potential action which mitigate the possibility of negative consequences to the client. And this might include, and this is dependent on the jurisdictional environment, including consideration of disclosure to relevant tax authorities. Next slide, please. We are proposing here some clarification to guidance and types of threats that might be created when providing tax planning services, but we are including here also some actions that might eliminate threats and some actions that might be seen as safeguards. So we try to give concrete examples for reducing the threats to an acceptable level in a situation of uncertainty. Next slide, please. A specific issue is this question of disagreement. Disagreement means that there is a position defined by the tax accountant and the position of the client. Next slide, please. We are trying to give guidance on a sequence of steps PA should take if disagreement with client arises. So we try to describe the thought process and the communication process. So if the professional accountant disagrees that a tax planning arrangement that a client would like to pursue has a credible basis, then we the accountant should inform the client of the basis of the accountant's assessment and communicate the client the potential consequences of pursuing the event of an adverse ruling, and advise the client not to pursue the arrangement if the client, if the PA thinking that the certain tax planning arrangement has a wider economic and reputational impact. We are also making clear that we want to avoid inadvertently limiting the client to an entity. So the scope is also to include individuals. So it's not only about corporation, it's also about individual. And then we are including guidance for PAs to consider communicating the details of the disagreement with those charged with governance if deemed appropriate. On the next slide, we are coming to the last point I want to highlight at this stage. It's about documentation. Documentation is a hot topic, and we had intensive discussions which proposal we would be appropriate here. Next slide. We are not imposing here a requirement. The reason why is that the documentation is heavily encouraged by the IESBA, and also in the no-class situation, we are encouraging documentation, but even there is no requirement. For the reason of consistency, we want to stay here with a requirement, but if you have seen the explanatory memorandum, we are expressively highlighting the issues in our questionnaire. So it's consistent with section 2 and 3 of the code. So the documentation is also a matter of quality management or engagement performance rather than an ethical behavior issue. So we are highlighting the importance of documentation, and we are also highlighting how such documentation will assist professional accountants. So we are all agreeing that doing documentation, proper documentation, is helping in the situation, but we are not imposing here a requirement. So my final slide before coming to the questions, and I see there are many questions now in the F&A segment. So on the next slide, there is the timeline. So you see, we have approved the exposure draft in December last year, and the exposure draft documents were published in February, at the beginning of February, and now we are in the consultation period, which will last until May 18. And in the September board meeting, during the September board meeting, we will have a full review of the exposure draft responses, and hopefully we will be able to approve our final pronouncement in December 2023. And those of you who have accompanied and witnessed and looked at our process in September 2021, we started, and we have promised, or wanted to be responsive, that we will finalize the process in December 2023, and we are hopeful and quite optimistic to keep this timeline, but we will see which comments you will send, and I want to encourage you to participate in this consultation. So next slide, please. And now, Carla, I think you have looked at the F&A section, and you will moderate these question session. Thank you.
Yes, thank you, Jens, for that informative session. So we do have a few questions that came through. We have plenty of time to go through them. So Jens, if I may, we'll go through one by one, and please chime in at any point if you have any further points to add. So the first one, the question is, does this do away with US statutory law, AICPA Code of Conduct, or any other US rule, including state statutory laws? So the quick question is no, the Code of Ethics doesn't override local tax regulations and jurisdiction. It is complementary to the local tax laws and regulations, so it doesn't override the local rules. Jens, do you agree?
Yes, I fully agree. We at the first step, we are jurisdiction neutral, and we are not. We don't want to interfere in national laws and regulation where processes are clear or established how to act in a situation of gray zone, for example. We do know that in certain jurisdictions there's a certain process of disclosing situations, structures, whether in the European Union or US. We are aware of such jurisdictional approaches, which are fine, which are there, but we are looking for a minimum, how to say, environment where we can provide PAs, especially in those jurisdictions where there is no such established platform, I call it. And we are also saying many PAs are doing tax advice in a cross-border situation. And we are specifically addressing this situation. And that's why we think even though you have an established environment in your own jurisdiction, this might differ from those jurisdictions where you are acting or where your tax planning advice may have consequences. So this broader perspective we want to highlight.
Thank you, Jens. The next question, I think you might have touched on a little bit. The question is, you may be aware that many countries' tax rules do not provide great scope for such real tax planning services. How do we process this in practical sense when no scope exists? For example, in India, we do not have many such tax planning practices, and it existed about 2 decades back. And going back to the situation where we, given circumstances of uncertainty in some of the scenarios we painted, which is not inclusive, that's in a text, to be able to enable the professional accountant to maneuver around some of these uncertain environment or circumstances they might come to face with, where especially where there's no specific scope within the law itself. Yes, I just wonder if you have anything else to add to that.
No, I think if you are in a country where such tax planning practices are not well established because there is no scope for that, no room for that, that's fine. We are not motivating you to do so. We are just want to make you aware of such discussions we have in many jurisdictions, and we are a global standard setters, and it's up to the national legislator, professional body to implement this. And if there is no need of changing existing rules or advising the members, that's fine. But again, in a cross-border situation, for example, if you are in a network, in a firm which has global outreach, I think it is important to understand. And if you have a client who has more than one subsidiary and is doing business in certain jurisdictions, I think there is a possibility that you are confronted with such tax planning arrangements.
Okay. Thank you, Jens. And that comes to the next question about the proposal, otherwise advising in connection with tax planning when there's no credible basis for tax planning. The question asked was, what does otherwise advise in connection with include? Would it mean unwinding of a tax planning arrangement, working with the client to defend against interest or penalties of tax authority that might be seeking to charge? What are your thoughts?
I think we are looking in this context to a situation where you are the tax advisors and you have sent, for example, your client to another third-party advisor, and this advisor is doing a certain tax advice, which in this example, you are considering either not having a credible basis or being not in line with your thoughts, put it like that. Then, and now you are doing the tax declaration and using the tax advice of the third party. You are not free just to copy paste it. You have to look at it because you are involved. And that means you are not directly doing the tax advice, but you are involved in establishing this structure. And I think that is something different from being in a position, in a more legalistic position, where you are fighting about something where there might be a credible basis, yes or no, and you have a credible basis in your assessment and you want to support your client and defend your client in a certain situation. And I think that is an issue we have seen and we are highlighting also in the explanatory memorandum. The situation which we are considering here is that you are, even though if others are involved, have your responsibility to make your own professional judgment and follow then, if you're coming to a certain outcome, this, and you can't delegate the responsibility to a third party. I think that in a nutshell is our intent.
I hope that answered that question. And Jens, moving along to the requirement in 380.13, the question is from US perspective, that might be a legalistic implication, and whether we have consulted with professional liability companies and obtained their input into this requirement. And the answer to that question is yes, we have done quite an extensive outreach to various firms, tax preparers and practitioners to get an understanding of the landscape in terms of them providing tax planning services on top of being cognizant of the risks that they're undertaking. So we have considered the input and feedback from these firms, in terms of the legalistic implication.
Yes, and I would like to add that this outreach activities includes the legal profession. So it's not just the accountants. We had also consulted with other professional organizations, international professional organizations, national organizations, and R380.13, in our view, but we are open for explanation, and that is exactly something which is relevant for the consultation and the feedback and the comment letter we would like to receive, is that we are putting the requirement in a soft way, because we are just saying the professional judgment is important here, because we are saying, if having considered the matters set out in paragraph R380.12, so finding a credible basis. And what a credible basis is, we have especially seen to the US environment, where we have seen that a credible basis, for example, might be there. And I'm looking at my American colleague, Andy Linzer, that there is a congressional paper where it said that a 20% success chance is a credible basis under US laws if you are disclosing this to the tax authorities and have some kind of authority for your opinion. So I think our requirement tries to be jurisdiction neutral and try to encompass also the US situation, but we are happy to reconsider if there are any further thoughts we haven't had before.
Thank you, Jens. So coming to the next one, it's a question whether the PA need to acquire legal jurisprudence as well to be better tax planning advisor, as per the ED discussed. So if I just would like to clarify, the Code of Ethics sets the ethical requirements for professional accountants carrying out tax planning services. It is not within the scope of this project or the code to be specifying what sort of qualification a person need to be a better tax planning advisors, although we do say you're required to keep up with your professional competency via profession development to be kept up to date. So I think that's what the question is about. Jens, I think that's where we're at here.
Yes, I fully agree.
Yeah, right. Moving on to the next question. Legislative tax laws are created by elected official in the public interest. How can a PA be asked to go beyond Parliament's intention as written in a tax legislation? It seems to second guess the Parliament's intent, such as the written tax law, which is detailed and thorough, and the PA's skill set in tax. What are your thoughts?
I think we are saying you should, as one element in certain jurisdictions, you should look at the Parliament's intention as written in the tax legislation. But normally, or in many jurisdictions, this written in tax legislation, there are further documents in where the intent is clarified if there is an ambiguity in the text. So this is a common interpretation rule in certain jurisdictions, but not in others. And we are not saying that the intent of the legislator is something which is the only element of establishing a credible basis. It might be. And we are saying, and in other jurisdictions, we have had such outreach activities, the pure text of a tax legislation, there is no interpretation possible. So that is a national specific. And our proposals we are making, we are just saying, look at the jurisdictional environment. And for example, another question I have seen is, what about DAX 6? This is, in the European Union, a specific legislation on tax planning and tax modeling. And for sure, this is relevant in all the jurisdictions where this regulation has to be applied. And if in your jurisdiction it's written that the only interpretation rule is the pure text, without any other. So there is no uncertainty. And if it is that, that might be a legal position. But nevertheless, as a professional accountant, you, even in these jurisdictions, should inform your client if you see some problems, as we illustrated with the Starbuck case, because it might have consequences to your client. And we all know cases where you haven't done this, and the client later is criticizing you for not giving a full picture because, for example, a foreign company is coming in your own jurisdiction, is not unaware of the environment. We are saying acting in the public interest means having a wider horizon. And that is, again, an issue of a certain jurisdiction where the concrete steps might be different. In jurisdiction A, there's a clear process to address something to the tax authorities, to an agency, and then you have a credible basis because you have given transparency to a certain tax arrangement. In others, there is a possibility that you don't have such a remedy. And that's why I think it's important for a professional accountant in a cross-border situation to make clear and to think about and to use your professional judgment.
Thank you, Jens. I'm just looking at time. I'll move on to a few more questions. So the next one is, if IESBA issued guidance obliging PA to consider effect of tax base of a country in determining whether to provide advice in respect of a project, do you think it might be creating a potential for confusion and conflict of interest? Could a tax authority argue that this requirement creates a duty of care that the PA owes to a tax authority, which could be in conflict with the duties the PA owes to the employer or client?
I think this conflict doesn't exist, and because we are not saying that there is an obligation to look at the tax basis of a country in whether to provide advice, yes or no. That's a confusion here, which cannot happen, because in the area of a credible basis, this wider perspective is not a factor. We are talking about the first step: establish a credible basis. You're looking at laws and regulation. You're doing that what a proper tax advisor is doing every day. He or she is looking at the pros and cons and tries to find a basis which is not, as some people propose, 51%, 75%, or whatever. We are not giving digits, but it is a basis where you can look at your own face in the mirror and say, yes, that's a credible basis. That's something I can stand for. And that is full stop, the basis where you are acting. There might be another step, and there might be a step where you as a tax advisor are saying, even though it is here a credible basis, this tax arrangement has consequences which I have to inform my client. And we are not saying that you are obliged not to advise your client. We are just saying you're obliged to inform your client. And then it's only your professional judgment whether you're continuing the service, yes or no. I think this situation can only occur, which is described in this question, if you're mixing up the process of establishing basis with the process of the Standback test, which comes later. So I think the step-by-step approach will solve this issue, hopefully.
Thank you for the explanation, Jens. And the next one, I believe we've answered that question before, but just to repeat, what is the purpose of this jurisdiction like US that have laws, rules, regulation already in place? As we mentioned at the start of the presentation and earlier, the Code of Ethics doesn't override the local rules and regulation, and the Code of Ethics is principle-based framework. It is there as a guidance to professional accountants, and as such that it is jurisdiction neutral. to be applied across jurisdictions, so it's not specific to a specific jurisdiction like the US.
And I just to make clear, no one questions that IESBA should make in the audit section NAS provisions, non-audit service assurance service prohibitions, even though we know that most jurisdictions do have a known legal framework. So I think that's not a good argument, because we have to look on a global basis and not on a national basis. And second point, we have to look at the cross-border situation, which in many jurisdictions is not touched by the national codes and laws and regulation.
Thank you, Jens. The next question talks about tax planning advisory to corporate clients in the view of the ED proposed by IESBA. Please throw some light into the role of clients in this sphere of tax planning as suggested by PA appropriately. And I think from reading the questions, it's meant to ask whether there's any additional specific area that the ED is targeting. And I would say no, like we mentioned that the example of services in the ED are examples not meant to be inclusive of all the tax planning arrangement that corporate clients can be entered into or provided by professional accountants. In terms of role of clients, unfortunately, the code of ethics remit doesn't extend to the client. It is a scope that's required professional accountants. Although in our proposal, we do have paragraphs in the ED that speaks to responsibility expected of management or those charged with governance in assisting the PA to carry out the tax planning obligations. So it's a reminder to the professional accountant that the clients have a role to play as well in assisting them to carry out their obligation as per the ethical requirement in the code. Right. Let's move along to the next one. Jens, there's a question that said there might be instances that PA will be engaged by client together with other tax advisors, including lawyers. Would these proposed rules not provide issues or conflicts, for example, to speak to these advisors?
It depends. There might be different rules being applicable if you're dealing with other professions. But I just had a wide outreach activity with the US lawyers and the International Bar Association, and there were no real big differences in the attitude towards tax planning arrangements. The only situation, always an issue, is the legal privilege, so-called legal privilege. But this is something more about confidentiality than about the question we are dealing here, because the issue of a credible basis is a common issue in each and every profession. There might be a difference in countries where there is no regulated profession which is not regulated. That is a specific situation, and the question there is whether there is a need of regulation for other professions, but that is more a national issue. The conflict situation is not there in our view if a professional accountant is making transparent which are the obligations under the national law and a code which is applicable. And in our perspective and our outreach activities have demonstrated that there is a specific role of the professional accountant because he has the obligation to act in the public interest, and the expectation to a professional accountant is here. But we are open for discussion with other professions, and we have been approached by other professions too, which are very interested because of this global discussion of Panama Papers and other papers and Pandora Papers, because it's not only the professional accountant who is the profession which is in discussion. For example, in my jurisdiction, the discussion is more about the role of lawyers doing tax advice, and there are many regulations now in place and discussions on raising the bar here for lawyers. So I think it's a global, if you're looking at the global level, you will see that the professions are coming closer together. And one last point, there's a trend of regulating not anymore a profession, but a certain service. And we are here perhaps in a situation where we're more looking at a certain service and which is a little bit professional agnostic, so to say. But as the scope of the IESBA code is to regulate the profession, yes, we are talking about professional accountants, but these thoughts are a little bit behind our exposure draft.
Yeah. Thank you, Jens. I'm just conscious that we've come to the hour and to the end of the webinar today. We do have a few more questions that we didn't manage to get to. So may I propose that we will answer these questions offline, and this would be after the other two webinars that we are scheduled for tomorrow in the afternoon of the Eastern time. Thank you everyone for your time today, and I'd like to express my gratitude to the task force dial-in today, Sanjeev Chowdhury, Andy Minzer, and Laurie Ansley as well, who's joined us. Thank you very much for your time, and if you have any further questions, please feel free to email any one of us on the task force, and we'll endeavor to get back to you with your answers as soon as possible. Thank you.
Thank you. Bye-bye.